Hello, everybody. These are doggy treats, though. I'll get some out for you. Don't worry. Let's see. Which ones are the ones you liked? Oh, yeah. You like these ones. Spoiled babies. Spoiled, rotten babies. There's two here. Don't let her fool you. Hello, everyone. Thank you to everyone who this is the second time you're hanging out with me today. Today, all the rest of the 4 parts of the back road carjacking story finished posting. So that whole playlist is together. And then, hey, stop it. I told you don't do it for the dog. It was like, yep, and I'm here for it. Fine, one more, and that is it. Only because one of those was kind of a half one. There you go, baby. Yeah, and then I went on earlier and we just ran with the docket Webster was doing at the time, and we had a councilwoman that was dealing in more than just her chickens. That was really fun. So of course I put that together and got that up. Yeah, it was fun stuff. Hello, Linda Applegate Love. Hello, Jerry Matthew Boyd. Hello, C-Rex. Don't forget to hit the like button, and then you're free to doze all you want. Hello, Nina Laura, honey. Hello, K. John Boom. Hello, Buzzy Pug. Welcome, sweetie. Hello, Manuel, honey. I'm sorry. That's my fault. I got lost. Editing, trying to find more stuff, more. And yeah, I all of a sudden I look at the time. Well, and I told Kendra, I'm like, hey, I might go on early tonight. And get back to my computer, and I'm like, oh, it's 11:20. I'm going on late. I still managed to get here on time, but just, not early. Like I planned. Hello, Spider-Man, honey. Hello, Margot. Oh, just the same old usual. Here with you. Hello, Sandy Hurd. Good. Yep, I'm going to post so much you'll be sick of me. Oh, he's good. He does a lot of soft sit stuff. Yep, I remember from before I became a streamer, I would watch him every once in a while. Hello, Jenny Green, honey. So I put together for tonight, we have one FTC with it's with Judge Ricky, and we have a couple cases in Judge Kristen Simmons' court, and we have one or two hearings in Hillary Braley's court. So we've got a little variety, a little bit. I tried to pop around and find different stuff and stuff we haven't run in a little bit. Hello, Lisette Panette, honey. Alien Earth on FX. Ooh, aliens. Well, Judge Ricky's always good. And I try so hard to collect his dockets. I did miss yesterday. I missed a couple of them. And then today I missed Judge Washington. But that's because YouTube is making it almost impossible to harvest content anymore. They just are. So until that gets figured out, as far as like how to be able to, do it the way that I've been doing it, but in a way that we can get away with it. Yeah, all I can do is basically wait until they're done and then try to get the whole thing all at once. And they blocked my IP, so I can only do stuff on my VPN. They're on to me. So yeah, that's just all there is to it. So hey, quit it. She's getting into stuff. She's good at that. She's good at that. Hey, Bandit, would you stop? Now you're just playing with me. She's very gently going like this on stuff and pulling it towards her. Well, hi, Ava. Yeah. You yell at the kitty for me. All right. Yeah, it's Bandit. It's Bandit. I'm all for seeing you guys dance with glow sticks. It's not something you'll see me do. I got Nord. That's who I went with, was NordVPN. And I don't know if maybe it's just that my Spectrum isn't strong enough to support it. I've got Spectrum, I've got fiber optic, and I've got the upgraded plan of it. So there should be no reason for the broadband issues that I've been having. So whatever. It is what it is, and we'll get through it, right? That's all we can do. We'll just smile and laugh and have a good time together, no matter what. Hello, Martha D, honey. Welcome back. All right, guys. Let's see what we got tonight. See who we can laugh at.
Is it King Mile? Do you have an attorney?
No, I don't.
Okay, TJ 2400769.
Yes.
Appearance for the record.
Patrick Abud on behalf of the city of Lansing, Your Honor.
And your name, sir?
My name's Neil Chang Miao.
Okay. Today was the date scheduled for a formal hearing. This is for an expired meter.
That's right.
Okay, did you all discuss this matter already?
Yes, we did.
Okay, and has there been a resolution?
I wouldn't necessarily call it a resolution in entirety. I do believe that this has worked its way up in front of magistrates on here. Not going to put words in his mouth, but in the conversation, he doesn't disagree that there was a violation of the meter in and of itself, but more on the fine and how that's been assessed to him is his issue.
What's the issue?
The issue is that, when I drove my car away, I didn't see the tickets on my car indicating that the meter has expired. That's the first thing. I didn't have the ticket on my car. I didn't know I passed it. Secondly, the first time I received the ticket, that was a $20 to $35 fine. And when I received that ticket, I made a phone call to the parking department immediately, parking service immediately. And the gentleman who picked up the phone told me, "Oh, well, okay, don't worry, that's a mistake." And then he hung down. So I didn't feel like I need to take any actions at all. So I even throw away the ticket. But a month later, I received I received an official ticket, increased to 65, something like that. Then I began to deal with the court. I even sent an email to explain my situation. That is, I think, on the May 3rd, something like that. And I made a phone call. To court, and I tried to explain my case. And then also they scheduled that informal hearing a month ago. This lady appearing in the court a month ago. And
Okay.
yeah, it's not about the money. Actually, even $65 I can pay in full, no problem. I just want to extend a little bit my situation.
I'm waiting to hear.
Thank you very much for your listening.
Yes, okay, so your issue was that you didn't see the ticket.
That's right.
Okay, but I have a picture in the file which lets me know, well, first of all, even before I look at the picture, let me be clear here. I've worked in government in this city and county for a long time. I'm a former assistant city attorney. One of the hardest working departments is gonna be those meter maids, you understand? Okay, they don't care who you are. I remember one time when I was assistant city attorney, and the city attorney was illegally parked. The city attorney, and the meter maid came out to write a ticket, and the city attorney said, "Hey, I'm the city attorney," and the response was, "We don't care." You understand? I get tickets if I don't park legally. You're gonna get tickets if you don't park legally.
My dad had to do parking enforcement as one of his roles when he first started at the police department, and periodically for several years. He ticketed his own mother, quite literally. Yeah, they don't care. Everyone's got to follow the rules.
I don't believe that they didn't put a ticket there. They took the time to even take a picture of your license plate.
Mhm.
Which is part of their procedure when they're leaving the ticket. I don't know what happened to the ticket, sir. I don't know if it blew off. I don't know if someone took it off after it was placed there, but it can't be the responsibility of the city. The other thing is we have invested in these lovely devices, these machines that you can download an app so that you can pay for your ticket to park there for the meter. You don't have to use coins anymore. And that app will alert you when you're tired. It gives you an update. You got 5 minutes left. The responsibility has now been placed back on you to even further be able to know when your time on your meter is up. So I believe that you were properly ticketed. I don't know what happened after that, but you are responsible for the ticket. There's nothing I can do about that.
That's why I'm here.
Yeah, it looks like
That's why I just
the
explained my
magistrate
case.
even, if you had to pay it originally, it was $15.
I didn't even know I have a ticket. So the first time I received the ticket from the city, it's a 35 already. I was trying to resolve that ticket already. I made a phone call to the, I even kept that my phone call log in my cell phone
Got it.
to show that I did trying to resolve the problem. I was trying to pay. And if when I made a phone call, if that clerk said, okay, go ahead and pay it, then I will pay it. He said, no problem. So he hand down, and then I said, okay, I don't need to do anything anymore. That's why I didn't pay.
Okay, I don't know who you spoke to. I'm sorry that happened.
Yeah.
Because it didn't get rid of the
If you
ticket.
have the complete record, you show that I sent an email.
I don't get computer records.
Oh, I'm so sorry.
Yeah, I only get the court file, which shows me.
If you want, I probably can forward to you that email to the court, and then the court.
You didn't bring it to court with you today, that you sent an email?
I have this email.
Did you show it to Mr. Abood?
Yes, you see, I sent an email on May 9th, and then I received the email May 9th coming back from criminal traffic and said, okay, you see, good afternoon. This email will serve as a confirmation the court has received your
Can you
document.
show me what your email was?
Yes. This is my email contact. I was trying to explain it to the court. Yeah, when I received the ticket, I made a phone call to that number that was shown on the ticket. And the parking service phone number on February 13th. I even have the time, I can show you the log. Now, officer, it's a male officer, pick up the phone, who received my phone call and said to me that my case was a mistake, and he expressed his apologies, and don't worry about that. And said that the case was dismissed, and I don't even worry about it. And the phone call lasted just about a couple minutes. And therefore, I have not taken any actions after that. This is the February.
It's similar
13th.
to what you've told Judge here.
Yes, yeah, and therefore I have no, but on May 9th, I received the
District Court.
District Court
ticket notice about it still doing that stuff.
That's right, and I made this phone call for this phone number, this is a court number, and the court clerk asked me to call back to the parking service again. But I got connected, and they said, no, the case has out of our office and to the court, so we need to contact with the court to continue it. So
Okay.
the parking
What's
service
going on?
doesn't care about that anymore.
The email represents is pretty substantially similar to what he has told you about the situation. He calls them.
He calls who? The clerk's office or
It's
the
like
parking lot?
The first call, I called the parking tickets first, and they said, no, don't worry, and then I dropped.
The parking ticket said, don't worry.
That's right.
Look,
That's right.
you were supposed to be showing me an email. They sent you an email and told you don't worry about it?
No, it's not the email.
Oh.
Email from him to the 54A District Court.
Got it. You
General
contacted
email,
the
and
clerk's
then-
office about what? Trying to pay it?
Yeah, I just trying to explain that to the court, and the court said, then if this is the case, then arrange me an informal hearing.
Okay, well, we're here for the formal hearing. I recognize you're saying that someone at the clerk's office said, don't worry about it, but you're gonna need to bring that person here, otherwise that doesn't help me.
Okay, yeah, that's the problem.
Nobody at the clerk's office can just dismiss your ticket for you.
Well, I just explained what I experienced. I have no experience of a bring-in who pick up the phone, but I can show you the phone log.
I mean, I believe that you made the phone call.
Yeah, we're not
disagreeing
just
with
telling
that.
that you did that. When can you pay the $50?
I can pay that right now.
Okay, we'll get you the criminal traffic window, and then guess what? Then you'll be all set. But you gotta pay the ticket, otherwise we're just gonna keep coming back here.
So there's no, it's just still $50.
It's $50. It was 65.
Now, pay the $50 bond last time already.
I can apply that. I can apply that, and you're all set. Thank you, sir. Okay, I have.
Anything to get out of a ticket. Oh my goodness. It was lost. It blew off the windshield. I threw it away because the clerk's office told me not to worry about it. Someone said it was a mistake. Whatever. No. Complete BS.
Advanced Corporation, 2500057881. Appearance, please.
Hello, Your Honor. Derek Knox here on behalf of Advancement Corporation.
You need to be stationary and prepared for court. We don't do walking around during court?
I'm stopping somewhere now. I'm out family vacation, so. Okay.
Okay, let's see. This was a code compliance show cause. How are we proceeding?
Yes, Your Honor. I did speak with Mr. Knox earlier. I just spoke to the code office. It is related to zoning. I'm having struggling with what to call it, a trailer or an RV on which I believe is the old Geyer building up here on Cedar. The use that he's using it for, that he's going to use it for, is more of a security. There's a big mural on the side of the building. I'm going to request the next recess the next available date. I want to see if there's something. I want to make sure that what we're charging is possibly is against all of our code, and if there's a resolution on this, it's not being used as a residential, is what he claimed. And that may or may not fit in. I would request a brief time to sort that.
When I look at the citation, it says outdoor storage of a recreational vehicle in the R-AR residential adaptive reuse district. Is that where you're concerned is?
Yes, it is a, if you call it that, but he's using it as it is a RV or a trailer. It's not a drivable one, but he's using it for security purposes because he has a mural that's about, I don't know, maybe 2.5 stories that was vandalized recently, and he had put it out there to let somebody be able to sit in there. That's my understanding to police that.
Right, but I don't, the way this is cited would make me believe that this is not about how he's using the RV or the recreational vehicle, but that it's being used in a residential adaptive reuse district.
Yes, Your Honor, I understand your concern. And what I'm doing is I would like to request an
You want time to look into
Yes,
that?
I want to make sure before I put my foot in my mouth or in the city's mouth that what he's using it for is going to fall squarely within get some words against it.
September 23rd.
September 23rd at.
If I may, Your Honor.
Yes, you may.
The trailer was put there, as Mr. Booth stated, because one of the murals was tagged, and the person responsible for the mural, first of all, the city of Lansing paid to get this mural done. They paid tens of thousands of dollars to get it done. So we put the trailer there as a means to secure that whole area to make sure nothing like that happened again, because the artist that did it had to come back and fix the area that was tagged. That trailer, security trailer, has been there for almost over a year. It wasn't until someone that uses our football field complained about it that we started to get all of these complaints and tags on our building from this Zachary Driver guy. But there have been no issues. We had no problems with that trailer being there for over a year as a security trailer to secure that area to make sure that that doesn't happen again. I'm totally open to the city of Lansing paying for a security company to make sure that that doesn't happen again. But since we've had that there, we haven't had any issues.
Why would
So-
the city of Lansing, I'm sorry, why would the city of Lansing pay for security detail?
Well, I'm just saying,
but
because that mural was paid for by the city of Lansing. The city of Lansing paid to get that mural done on our building. It was
Clearly, it's a very important mural to you, though, even though it was paid for by the city of Lansing.
a part of a.
the city of Lansing pays for a lot of things. They're not gonna pay for security to protect those things. And just because they may have paid via grant or gift or otherwise for a mural, doesn't mean that they're now gonna provide security to keep it from being vandalized. The other thing that I need to state is just because you didn't get cited for a year does not mean it wasn't a violation. I don't know if it's a violation or not. The city attorney wants to do his due diligence to make sure that he's moving forward appropriately in this. And so that's why the court's gonna give him time to do that, because you shouldn't be cited for something that is not a violation, and that's not wrong. However, just because you got away with it, let's say it is wrong, just because no one reported it for a year does not absolve you from the responsibility of following the code if this is a code violation. I don't know. That's for Mr. Abud to research and then provide evidence supporting for or against to the court. If you believe it's not a code violation, then you have the right to bring your own evidence to show that it's not a violation at the time of the hearing. And I should also advise you that I don't hold actual hearings via Zoom. So if there is going to be a hearing, you would need to appear in person, okay?
Understood.
Because I can't present evidence, I can't receive your evidence that you want to present via Zoom. So that's why it has to be in person. But if you all resolve it, then Zoom is just fine. So September 23rd at 11 works for you, sir?
Yes, that should work.
Okay, we'll see you September 23rd at 11, and hopefully all goes well with the city's investigation to resolve this. Thank you. This is the matter of Lansing Automakers versus DeQuan Stitt, 1102391. Mr. Stitt, are you there?
Yes, ma'am.
Okay, Mr. Stitt, my understanding is that you did go into a private meeting room with Mr. Smith, who represents the Lansing Automakers. This was for a discovery hearing, also known as a creditor or debtor's examination, and that you refused to answer any questions. Is that accurate, sir?
I didn't know who he didn't say who he was or why he was asking these questions. I don't really know what's going on. I just showed up to court.
Okay, that makes sense.
So
If you don't know who's asking you questions, I wouldn't give financial information either.
So I started.
This is a credit or debtor's exam. You owe LAFQ some money, and they're trying to figure out how they're going to get it.
Yeah, I'm trying to figure out how much money and some other stuff too, because some other stuff went on. I'm just trying to figure out how much. I don't know how much they sold my car for, because they sold it and didn't really tell me anything after that, because I tried to pay the bill, and then they sold my car, and then for some ridiculous.
You can contact the clerk's office and get a copy of the judgment.
Okay.
And that should tell you what the judgment amount is for. However, because this is set for an official court proceeding to discover information as to how to procure payment on a debt, I'm going to reset this matter. You'll be required to come in person this time, okay?
Okay, what difference is that going to make?
What do you mean, what difference is it going to make?
What difference does it make if I show up to court and then on Zoom?
Because you're going to handle it in front of the judge this time.
I'm in front of the judge now.
Give me a court date. September 9th at 2. September 9th at 10, at 2, in person at the court.
That don't make sense. Oh well.
Yeah, well, it may not make sense to you. It makes sense to the court and to the process. You can appear in
I
person
bet
if
it
you
do.
don't. If you don't,
Everything makes
bench warrant
sense.
issue. If you don't, a bench warrant will issue.
Okay, I'll be there. I'll be there.
Thank you. You have a good one.
Still makes sense. That's stupid.
What's stupid is to go back and forth in the courtroom. That's stupid.
What's stupid is arguing with that judge, because she don't mess around and she's gonna remember you. You don't want her to remember you.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Christian Michael Leal. It's case number 2024 CR 322. James Watts appears as defense counsel, defendant from the Butler County Detention Facility Zoom location. Brett Sweeney appears for the state of Kansas. This matter comes before the court at this time for pretrial conference. What formal announcement is made, Mr. Watts?
Your Honor, a discussion with the state. It's my understanding my client would plead guilty to count one of the information possession of fentanyl. The state would dismiss the following, the second count, a misdemeanor. At time of sentencing, Your Honor, we believe Mr. Leal will fall presumptive probation in all likelihood of Senate Bill 123. We think he's going to be a G on the grid. We won't know that, of course, for certain until we get a PSI.
Mr. Sweeney, as Mr. Watts announced consistently with your understanding as to how this legal case would be handled?
He has, Your Honor.
I'll address the defendant at this time. You've heard what the attorneys have announced. Are
Yes.
you in agreement with what has been announced here, and is it your intention to enter this plea?
Yes.
Okay, what plea will you be entering, Mr. Leal?
The guilty.
I've got a number of questions I need to ask you regarding the taking of a guilty plea. If there's anything asked of you that you do not fully understand, I will give you the opportunity to confer privately again with your lawyer. Just let the court know if you need that time to get some private advice, okay?
All right.
State your full legal name for the record.
Christian Michael Lell,
How old are you right now?
26,
What's the highest level of education that you've attained?
11th.
Do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing in court here this morning?
No.
Have you ever been adjudged to be mentally ill?
No.
Are you currently under the influence of alcohol or any drug?
No.
Are you currently taking any type of prescription medication?
No.
Are you supposed to be taking mental health medications that you are not currently taking?
No.
So as you sit today, do you believe your mind is clear and that you have a full understanding of what's going on here in court?
Yes.
Did you receive a copy of the original charging document in the case?
Yes.
Do you understand the nature of the charge in count 1, possession of fentanyl?
Yes.
You understand that when you enter a plea of guilty, you are admitting that act that's been charged by the state?
Yes.
You also understand that when you enter a plea of guilty, you give up any legal defenses that you might have had to that charge?
Yes.
You understand that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Watts, and that you could present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes.
You also understand that in such a trial, you personally would have a privilege against self-incrimination, which means that you could testify in your case if you wanted to, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described?
Yes.
You also understand that you have a right to a trial by jury. Before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes.
You understand that you have a right to appeal a guilty verdict if you have a trial?
Yes.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea?
Yes.
Are you aware of the sentence that could be imposed as a result of this guilty plea that you're attempting to make?
Yes.
On the level 5 drug line, which I currently have before me, in the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. In the worst criminal history category of A, you could receive up to a 42-month sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. As you sit today, we do not know with certainty what your criminal history is. You, better than anyone else participating, really should know what your own criminal record looks like. But that will be researched by the Court Services Department. And based on the outcome of their research, as of the date of sentencing, that determines where you fall along the level 5 line, and then you'll be sentenced accordingly. You understand that?
Yes.
You also understand that if you have a person felony on your record already, you would be presumptive prison in this case?
Yeah, I don't have one.
Okay. Do you also understand that you could receive up to a $100,000 fine for this offense?
Yes.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes.
Do you understand the concept of Senate Bill 123?
Yes.
That is a state-sponsored drug treatment program which you may be required to participate in as part of your sentence in this case. Do you understand that?
Yes.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes.
You understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes.
You understand that the Kansas Sentencing Guidelines Act is much more than the grid page I referred to earlier. It's an entire book of sentencing rules and laws. Do you understand that if any special rules apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you understand that?
Yes.
Now, have you had an ample opportunity to discuss legal matters like that with your attorney, James Watts, before proceeding here today?
Yes.
You want any more time with him privately now before we go further?
No.
Are you satisfied with the services and advice given to you by Mr. Watts?
Yes.
Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No.
You understand that if there had been any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes.
So let me ask you formally, how do you plead to the charge in count 1, possession of fentanyl, a level 5 drug felony?
Guilty.
When did this take place, Mr. Leal?
I think February of 2023.
The charging document says January 19 of 2023. Is that approximately when it happened?
Yeah.
And it happened somewhere in Butler County, according to the state. Where in Butler County was it?
Augusta.
Okay. Did you possess fentanyl on that date?
I had a little metal tube that I used when I used to smoke it. I smoked it through, but I didn't have any in it. But
if there was a positive test for the substance of fentanyl in that tube,
they said it was residue or something.
all right, it is because you had possessed fentanyl, correct?
Yeah.
All right. So at this time, are you entering a plea of guilty and accepting conviction for possession of fentanyl, a level 5 drug felony?
Yes.
Are you making this plea freely, knowingly, and voluntarily?
Yes.
All right. Mr. Watts, do you know of any legal reason why this court should not accept this defendant's plea?
I do not, Your Honor.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
All right. The court will address the defendant and ask him, do you know of any legal reason or any other good reason why the court shouldn't accept your plea?
No.
Court will accept the guilty plea made by the defendant, finds that that plea is made voluntarily. He has an understanding of the nature of his charge and the consequences of his plea, and a factual basis for the plea does exist. Court finds him guilty and adjudges him therefore convicted of possession of fentanyl, a level 5 drug felony. Any other charge of the charging document is dismissed. Pursuant to plea agreement, the court orders a pre-sentence report be completed to determine this defendant's criminal history, and the court will set an appropriate date for sentencing. Does this defendant have other holds on him?
Not that I'm aware of, Your Honor.
Okay, how come you're not out on bond, Mr. Leal?
I don't have the money for the bond, sir.
Where do you live?
I live in Wichita and 3850 South Meridian with my sister.
You have a $1,000 bond. You couldn't make $1,000 bond?
I don't have the money for it right now. I haven't had the money for it since I've been here.
What would the state's position be on an OR bond for this individual pending sentencing?
Your Honor, I was just thinking about that. I don't know that I would have an objection to an OR bond, given the fact that he's now got some level of oversight, level of supervision, with the stuff that Senate bill evaluations are going to require. So that's kind of my take on it.
All right, Mr. Lil, here's the thing. Since I've accepted your plea and you're now convicted, it's likely that you're going to be required to do some pre-sentence assessments. If you sit right where you are right now, I know I can get them done. There'd be a risk needs assessment, and then there'd be a separate substance abuse evaluation that would need to be done. Those have to be scheduled, follow through on. We allow about 8 weeks to allow that all to take place, but you would have to make sure that you could get yourself to these appointments and follow through on the process.
I have transportation out there. My sister, she can give me rides to any appointments I need.
So you're telling me I could let you back out in the community, and when sentencing came around, we'd still be ready to do sentencing because you've taken care of everything.
Yes, sir. I know I've had no problem getting to any appointments at all.
All right, I'm going to give you an opportunity to prove that, Mr. Lil,
Okay.
but let me tell you something. I will hold you responsible if they don't get done.
I understand.
Okay. And with that understanding, I'm going to go ahead and convert your bond to OR at this time, Mr. Lil. If you don't have any other holds, you're going to get out today.
All right, thank you.
Okay. But you got to follow through. And the best way for you to follow through is that the very first thing you do upon getting out is that you pick up a phone and you call the court services department and you make sure that you get coordinated with them as to what you need to do and when you need to do it.
Okay.
Do not delay in doing that. Do you need a telephone number for them?
That would be helpful, yeah.
Okay, and then maybe detention can write this down for you.
Yes, sir.
I think that number is 316, and you'll just need to call that just as soon as you get out and get situated back at home.
Okay.
Call them and make sure you get coordinated. Or perhaps you might even go by and see them today after you get out, because they're right there in El Dorado. Butler County Court Services at the Judicial Center. Because I just want to make sure that everything that you need to do gets done, even though that I've taken you out of confinement.
Okay.
Okay. And I'll tell you, Mr. Leal, it was the court's intention all along that you'd make that bond and be out in the community anyway.
Okay.
It's unfortunate you couldn't make it, but the bond was set very low and very reasonable. In fact, I don't recall a case in recent memory where the bond was set that low.
Yeah, I'm not really able to make money till I get out there and start being able to work, you know.
Well, I want to encourage that. Just make sure you take care of these assessments.
I will.
All right. So let's set our sentencing date, counsel. Are you sure you've got a place to go and
Yes,
stay,
sir.
right?
Yes, sir.
Okay. I have such few dates that I can offer, counsel. I'm going to stick with that March 12 date that I used this morning. Mandy, do we have 9 o'clock available?
Yes, Judge, we do.
Okay. Will that work for you, Mr. Watts?
Yes, sir.
Okay. 9 o'clock a.m. It's an early morning start. And I'm going to order the defendant to appear at the Butler County Judicial Center in El Dorado. So in other words, the courthouse building where we conduct court in El Dorado, that's where you need to be.
Yes,
For
sir.
security, when you check in, we'll get you to the location where you need to be to participate in your sentencing. 9 o'clock, Wednesday, March 12th. Try to get there a few minutes early.
Okay.
Okay.
All
I don't know
right.
what else is going on in the courthouse, and there may be any number of people checking in at that time. So come a little early to make sure we can get started at 9 o'clock.
Okay.
Wednesday, March the 12th.
If I may, Your Honor,
You may.
Mr. Leal, if you get out when you bond out, in addition to contacting court services, call me. You have my phone number? The
Yeah.
paperwork?
Yeah, I have it.
Okay. Call me. Make sure I have good contact information for you.
Okay, I will.
I need to be able to get a hold of you.
Okay.
That's good advice, Mr. Leal. Make sure you follow through on that too. Do you have any questions about
No,
what we've
sir.
done here today, Mr. Leal?
No, sir.
Okay, Mr. Sweeney, is there anything else we need to address currently in this matter?
No, Your Honor.
Mr. Watts, anything further?
No, sir.
Okay. And at this time, this matter will currently be in recess, and this meeting may be ended.
And now to today.
Apparently, it took some time for Mr. Leal to be taken into custody. Pursuant
How did that PR bond work out for you?
to that order, And the court did grant judgment on bond back on August the 5th in the amount of $1,000 against this defendant. The defendant was apparently eventually picked up and brought before the court on August the 6th. Mr. Sweeney, do you know when he was actually taken into custody on the warrant?
I do not, Your Honor. I was trying to look at that as well. Obviously, I would change maybe the jail time credit by a little bit, but it looks like around August 6th.
All right. Court will proceed further with sentencing proceedings at this time, and I'll ask first the state's attorney, is there any objection to the criminal history which is stated in?
No, Your Honor.
Any objection by the defense, Mr. Watts?
Your Honor, I have reviewed the criminal history with my client. We believe it is correct. I will note, I had to take just a moment to double check the rules on the application of the juvenile arson, which is number 12 in the criminal history. It is appear to be correct since it was prior to his 25th birthday.
Very well. Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score F, and the court will proceed further accordingly. Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in this case here today?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Mr. Leal, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, sir.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Are there any victims or members of a victim's family present who desires to address the court in relation to the Leal sentencing? The court finding no such persons present, at this time we'll ask for recommendations from counsel regarding an appropriate sentence for Mr. Leal, beginning with Brett Sweeney on behalf of the state of Kansas.
Thank you, Your Honor. Your Honor, I had to go back and refresh my memory, but way back in January when we had the plea, the state had agreed to the mitigated box of 16 months in the Department of Corrections. So the state will go ahead and obviously stick to that recommendation. Mr. Leal would be eligible for the maximum good time percentage of 20%. He would have a post-release supervision duration of 12 months. If my math is correct, with the additional, what I think is about 6 days, he would have 117 days of jail time credit. And then given his placements on his pre-sentencing evaluation scores, which were very high risk, the state's recommending up to 18 months of community corrections probation with a Senate Bill 123 treatment modality. The state's recommending that all of the conditions within the PSI be adopted. And that's obviously including first and foremost the Senate Bill 123. Everything else appears to be standard. Your Honor, the state's not requesting a fine. That's again pursuant to plea agreement. We are requesting the court costs in the matter, $300 payable towards the Senate Bill 123 treatment, community corrections fees, supervisions fees, $400 KVI lab fee, and then bids and attorney's fees if the court finds those appropriate.
Thank you, Mr. Sweeney. Mr. Watts, your recommendations regarding an appropriate sentence.
Your Honor, will be very brief. The recommendations of the state are in keeping with the plea agreement. We believe they are appropriate. We would join those recommendations. I don't know that I have a whole lot to add, Your Honor. Thank you.
Your fees and the representation of the client, Mr. Watts.
Judge, this would be billed to bids at $1,100.
Thank you. At this time, the court will address the defendant personally, and I'll ask Christian Michael Leal if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Leal?
No, sir.
Very well. Court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in the case for the offense of possession of fentanyl, a severity level 5, drug, non-person felony, in which the defendant is a criminal history score of F, thus placing him in grid box 5, drug F. The court hereby sentences the defendant to the standard term of 17 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court imposes no fine on that count.
He got an F on his PSI. Fitting.
This court declines to follow the joint recommendation for a mitigated sentence. Mr. Leal, I don't see this as a mitigated sentencing situation. You essentially absconded from this court for approximately 6 months. Instead of facing the music at your original sentencing date in March, here we are in August, still messing around with this. So the court believes that the standard sentence is appropriate in this case. The court does find that the defendant's combination of a high probability of a substance abuse disorder on the SASE combined with a very high score for risk assessment purposes on the LSCMI indicates that this is a mandatory case for Senate Bill 123 drug treatment. The court will require the defendant to participate in an appropriate substance abuse program for up to 18 months as part of an up to 18 months community corrections probation. The court does find that community corrections supervision is appropriate due to the fact that this is a Senate Bill 123 case. The defendant is ordered, as part of his probation conditions, to follow all laws, report to an officer as directed, to successfully complete a Senate Bill 123 approved program, including any aftercare recommendations that may be made. He shall not possess or consume alcohol or illegal drugs while on probation. If the officer believes that it's necessary, the court will require the defendant to obtain a substance abuse assessment from an approved provider without delay and abide by the recommendations of the evaluation. This evaluation would be in addition to and any initial SASE evaluation that was done in the case. At his supervising officer's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to any program requirements, gain and maintain employment successfully throughout his probationary term. Mr. Leal, under the table work is not work that this court approves. Any work that you do must be for an employer with general withholdings on a regular payroll basis. The defendant is ordered to notify his ISO of any changes in employment status, residence, telephone number, or email address within 24 hours of any such change taking place, abide by any curfew or travel restrictions imposed by his officer. And again, the focal point of this probation, Mr. Leal, is for you to be successful in a substance abuse treatment program. You must meet all requirements of such program once admitted. The court will be assessing a felony docket fee, felony probation fee, community corrections fee, $400 restitution to the KBI laboratory, $300 reimbursement to the Senate Bill 123 program. This court will waive all bids assessments in this case, despite the fact the court believes that Mr. Watt's services has been valuable to Mr. Leal. The court notes that Mr. Leal has a $1,000 judgment on bond against him. The court has taken that obligation into account. I don't intend to relax or do anything with that bond forfeiture judgment. But taking that into account, all bids assessments are waived in this case. Regarding the issue of jail time credit, do we have any accurate information as to when he was picked up most recently on the arrest warrant? We know he made an appearance before the court on August the 6th. Did he serve any time before that?
I don't know. My client tells me approximately a week. That would be about August 6th. I don't know when.
I don't know why he would have been in custody for a week before he saw a judge. That just doesn't make any sense to me.
Pardon me, Your Honor.
Yes.
Deputy Culpepper at the jail. We picked up Mr. Lell from Sedgwick County on August 5th.
Okay. Do you know why he was picked up in Sedgwick County? Did he have other matters over there, or was it on our warrant?
I'm not exactly sure, but they did notify us saying that he was ready to be picked up on Butler County charges.
All right, it very well could be that he's entitled to jail time credit for that time in Sedgwick. I'd ask the county attorney's office staff to look into that and make sure that any additions to jail time credit for Sedgwick County time is added. The court will, at this point, order 118 days of credit to be included in the journal entry, plus any Sedgwick County time that would be appropriate to add. Unless Mr. Leal was in custody on some sort of mandatory consecutive felony, Mr. Sweeney, and I'm going to direct it, that any of the time that he served over in Sedgwick County before his transfer to Butler be included in the jail time computation.
Yes, Your Honor.
All right. All right, Mr. Leal, at some point in the future, you may have the right to seek expungement of one or of this offense. Certain statutory limitations do apply. I do want to go ahead and establish some sort of standard for payment in this case. Mr. Leal, if you get out, what type of work do you intend to be doing?
I got a landscaping job business that, or a friend that has a business that they can get me into. And it'll be paid, you know, it won't be, I should be on a payroll, you know.
Okay. And what kind of money do you expect to make at that job?
12 an hour.
All right. I'll excuse payment in August, but starting with the calendar month of September and all subsequent months, the defendant is ordered to pay a minimum of $75 a month on his obligations. Certainly encourage you to pay more if your circumstances allow, Mr. Leal, but there'd be a $75 calendar month payment starting September. Mr. Leal, under certain limited circumstances, a criminal defendant might have the right to appeal their conviction to an appellate court having jurisdiction. And if such defendant is unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal, and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. And I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Mr. Sweeney, are you aware of any other sentencing-related matters which the court still needs to address?
No, Your Honor.
Ms. Ashenfelter, do you have any questions as the community corrections representative regarding the court's sentencing orders?
No, Your Honor.
What direction do you give Mr. Leal if he is to be released from jail at this time and the court does release him on probation in this case at this time? What direction do you give him?
Your Honor, if I could get a brief breakout room with the defendant, I'll go over all of that with him.
I think we can accommodate that. So Mr. Leal, even after the court recesses, stay on the meeting and then visit with the probation officer who's on the meeting, okay?
All right.
And Your Honor, if I may join that breakout briefly.
You may. Mr. Watts, is there anything else that you believe we need to address here?
I don't believe so, Your Honor.
Mr. Leal, any questions regarding the court sentencing orders?
No, sir.
Okay, I hope that I don't have to review your case in the future. If you weren't mandatory Senate bill, Mr. Leal, I don't know that this would be the result that would have been reached. But you've got another chance. Be successful on your treatment, be successful on your probation, and then hopefully no further action will need to be taken on this sentence.
Yes, sir.
There's nothing further at this time. The court will recess the court proceeding in the case, but leave the Zoom meeting open for conference between probation officer and probation.
Excuse me, Your Honor, I'm currently in the bathroom. Can I get a brief moment?
Okay, Mr. Horgrove, we're going to try this again. Now calling 22W005618. This is the Township of Ypsilanti versus Quentin Horgrove. Can you state your name, please?
My name is Quentin Hargrove.
Okay, thank you very much. So we are here today for a review of payment in this case. So this was a no proof of insurance citation from November 11th of 2022. You operated a motor vehicle on Michigan Avenue at or near Spencer with no proof of insurance. So that's a civil infraction. There weren't any criminal penalties associated with this, okay? No jail time, no probation. There is, however, a fine. This went into default about 1,000 years ago. What is this? Just a second. Do you have a staple river?
If I might say something, Your Honor, just real quick.
Well, I'm looking at the citation, and there was a proof of insurance stapled to it that had an effective date of October 20th, 2022. And your license has been suspended since 2022 because of this citation. Were you aware of that?
I didn't even know that. I've been pulled over. Like, you know what I'm saying? Like, I've got re-registered my car. I've got a new license. I've been pulled over several times. Like, you know what I'm saying? It's like, what? And then I get this letter in the mail talking about your license is suspended from a no proof of insurance from 2022. On top of, like, I've already got court tomorrow for something else. It's like, what do you mean? Like, and like, and it's like, I don't have no recollection of this. I'm an automotive technician, like by trade. I'm currently not working, but I usually work in an automotive field. If my license has been suspended, that means I couldn't have had my job at that dealership all that time. You know, like, shouldn't that have came up on like my background check when I applied that I don't have a license or something? I don't know. Like, I don't know.
So
It's kind of funny. It's a little bit.
it's, well, funny and yeah, a little bit strange because the date on here, it looks like it was.
You said it had insurance stapled to it, dated October 20th, so a month before I got pulled over.
Yes. You do need to have it in your car.
Understandable. Yes.
Okay.
I think my phone died. I think I had it on my phone. I think my phone was dead.
And actually, I think there was a note on the citation about your phone being dead. So just a second, please.
And then, I mean, I guess I forgot I had it, you know?
Yeah, that happens.
I haven't had a license for 3 years.
Well, no, so it looks like the suspension just went into effect, actually.
Okay.
That's what I am taking a look at right now. Okay. Are you able to make a $45 payment?
Right now, I don't have $45. Give me, I don't know, a couple weeks, I can pay $45. Like, well, also, I can't Uber anymore because my license is currently invalid. And so I don't really have like a means of income at the moment.
Okay, hold up a second. Okay, I do not do this particularly frequently, but given the circumstances and the fact that there was proof of insurance dated prior to this stapled to the actual citation, and it did state on the ticket that your phone was dead when you were pulled over, I am going to waive the fines and costs in this ticket and close the ticket.
Thank you very much, Your Honor.
You are very welcome. Hopefully I don't see you again anytime soon.
Hopefully you're not who I have to see tomorrow.
Hopefully not. Hopefully
No,
not. So, okay, there you go then. You are free to sign out. Thank you.
Thank you very much. Have a wonderful day.
Yes, drive safe.
Will do.
Now calling case number 09W189638B. This is the Township of Ypsilanti versus Robin Nicole Dunnigan. Can I have you unmute, please, and state your name for the record?
Robin Nicole Dunnigan.
Okay, thank you very much. So today is the date and time set for a show cause hearing in this matter. This was a citation from quite a while ago. It looks like you pled guilty back on February 9th of 2020, or not 2020, 2010, excuse me.
Yeah, I have no idea what this is.
Okay, so this was a citation from, as I stated, back in 2010. It was a misdemeanor citation interfering with police.
Yeah, I have no idea what it is.
Okay, well, you have a balance of $420. So how much time? For a citation, a misdemeanor citation that you pled.
I have no memory of that, ma'am. I have no idea what this even is.
Okay, so.
Is there anything else you can give me? Because like I don't know what this is.
August 9th of 2009, you were cited for the following.
Okay.
Have interfering with police, that's the remaining citation here. Possessing drug paraphernalia.
Can they even do that? Like, why am I getting, why is this, I've been in jail since then. I've changed my life since then. Like, I don't understand where this even came from. Like, I have been in jail for a long period of time since then.
Okay.
And then I have been out of trouble for like 10 years since then.
Okay. Well, I am glad to hear that.
Yeah.
So,
I mean,
as far as the citation goes, though, you pled guilty to a misdemeanor back in 2010, so they don't just go away.
2000 and, it don't just, yeah, but I've been in jail. Like, why didn't it come up then?
I don't know what to tell you.
Well, is there any type of lawyer or something like that? Like, I don't understand why this is now coming up when I was in jail for like 3 months in 2013, 14, something like that. Not 14.
Okay.
So 11. I don't even know. I have no idea.
Okay. So I can have you talk to the public defender intern so that they can have your contact information. At this point, you just have a balance in this.
Yeah, but I don't understand why I take care of a special needs child, and I am on limited income for Social Security for him. I can't work because he's autistic, and the school can't hardly keep him there. I don't have $400. I don't know when I'd have $400. Like, I've changed my life. Like, I don't even remember what this is.
Okay, Ashley Moten, Assistant Public Defender. I just want to confirm because the way we get the docket is very strange. So is the case number 09W189638?
B, ends in B, but yes, and it's just a show cause hearing because.
Right, that's why I can't tell if with this new docket
But I've been
if
in
we're
jail
assigned
for
to
not
be.
giving you guys
Ma'am,
money for other
Would you like
things.
the? Okay.
Just one moment. It doesn't tell us if we are assigned to it or not. And then there's also not a case in our system. So I was going into the other system to try to check to see if.
Well, generally speaking, at this stage of the game, you wouldn't be assigned to it since it's both very old and she's not being arraigned. She just owes money. It looks like she may have had a private attorney back in 2009. There's a Mark Collar listed here.
Okay.
So the point of having her speak to someone from your office would be more so that it could potentially be explained why misdemeanor charges don't go away.
Right. And I was going to ask if I could go in a breakout room with her, but I'm not even seeing this case in my court. So I guess I wouldn't really have anything to provide to her. This new system is very limited on everything, or at least limited on the information they're allowing us to view.
Okay, so Attorney Moten, I am going to send you a link to the ROA, and I'll have you go into a breakout room with her.
Okay. Okay, so that I was wondering, because we've tried that in our office before. It doesn't work when you try to send cases to us. Or we try to send cases to
Then let me try one other thing. I did send her into a breakout room, so let me send you that invitation and just look at the chat, okay?
Okay.
Okay. So I have let Attorney Moten know that that matter will be adjourned to October 14th at 9 in the morning over Zoom in front of me.
She didn't even want to bring her back in and deal with her after the attorney had explained that misdemeanors don't just disappear. She pled guilty. She owes the money. It's not just going to vanish. Yeah, I can only imagine, especially considering after Magistrate Braley muted her, she was still going off as if they could hear her. Yeah. Yeah, I wouldn't have brought her back into the main either. All right, guys. Thank you guys all so much for coming and hanging out with me tonight. This is a lot of fun. Yeah, pretty much. Pretty much. Yeah, I had a cleaning lady who she had been sober for 8 years, and all of a sudden she was hit with charges from something that had happened back when she was a user. She had gotten pulled over, and they suspected that she was on something and sent it to the laboratory. And when it came back, she had tested positive for Sudafed, but it was, at the time, it was like one of the conditions that she couldn't take. She couldn't take certain cold medicines because they would anything that would alter her ability to drive or whatever. But yeah, they charged her for it 8 years later. So yeah, they can do that. She fought it hard, and she ended up taking some kind of a plea deal on it or something and going on probation. But I mean, even she was like, yeah, well, for all the times I didn't get caught, I think having to eat this one makes sense. Well, I love you guys. You think I'm here for you? You're here for me. Yeah, that's probably what it was. I miss, oh man, there was one, it had a green coating on it. It worked for everything. Like it was taken off the shelves because it was being used to cook with. But it had a green coating. There's a spider. I have to get a spider out of my house and put it outside. Okay. I love you all. Be safe, be well, sleep sweet, and much love.